Hi, I'm Michelle Driscoll, Policy Coordinator with Michigan Alliance for Families. Thank you for tuning in to this video about discipline protections for students with disabilities. This video will cover federal and state regulations and rules, as well as guidance from the Michigan Department of Education Office of Special Education. I'm going to discuss discipline requirements for students with disabilities who receive special education services, as well as protections for students who have disabilities but are not yet eligible under the Individuals with Disabilities Education Act. I'm going to review the concepts of basis of knowledge, when a school should have known that a student is a student with a disability, what constitutes a disciplinary removal, what the manifestation determination review is for, and why the 7 factors in Michigan law must be considered. I'm going to touch on interim alternative educational settings and special circumstances, and wrap up with procedural safeguards and dispute resolution options that are available to parents. I know discipline is a complex topic, and I'm going to share a lot of information with you, so hang in there with me, please, as we get started. The information I'm going to be discussing today come from these federal and state laws and rules. The focus of this video is on school-age students. The Individuals with Disabilities Education Act, the IDEA, is a federal civil rights law that entitles eligible children and students to receive a free, appropriate public education in the least restrictive environment. On the screen are the sections of the IDEA I will be discussing. The IDEA sets the minimum requirements. States can do more than the federal requirements, but they can't do less. In some cases, states have a different rule that goes beyond the federal requirements. Michigan Administrative Rules for Special Education, or sometimes called MARS, are how the federal laws are implemented in Michigan. While there are no specific discipline requirements in MARS, there is information about topics I will discuss, including shortened school days, the manifestation determination reviews, about discipline and placement, and obligations of schools to support students' behavior. I'm going to discuss information in the Michigan Revised School Code about discipline requirements specifically related to consideration of 7 factors before suspending or expelling any student. This is not just for students with disabilities, it applies to all students. One cornerstone of the Individuals with Disabilities Education Act, the IDEA, is the entitlement of each eligible child with a disability to a free, appropriate public education, FAPE. Let's break this down just a bit. Free means special education and related services are provided by public schools at no cost to parents. Schools cannot deny a FAPE due to the cost of services. And schools can charge fees if children without disabilities are charged the same fees. Appropriate means that students are entitled to an education that meets their unique needs. And the Individualized Education Program, the IEP, provides information about how your child's education is personalized to meet his or her needs. The IEP outlines how the special education programs and related services are provided and lists your child's educational goals. Public means that children receiving special education programs and related services have a right to receive an education provided by the public school system. And education means that every child who is eligible for special education services has a right to an education. The education should prepare all children for their future, including post-secondary education, employment, and independent living. The primary vehicle for providing FAPE is through an appropriately developed individualized education program, an IEP, that is based on the individual needs of the child. The responsibility to make a FAPE available to all students with disabilities applies to all public schools under federal law, and this includes local school districts and public school academies such as charter schools. Another cornerstone of the IDEA is least restrictive environment. LRE means that to the maximum extent appropriate, all children with disabilities are educated with children without disabilities. The IEP team decision about what is considered the least restrictive environment for an individual child is based on the child's unique needs, not the category for which the child is eligible for special education services, and not what is available or possible based on the school district's resources like staff or money. Removing a child with disabilities from the regular education environment should only happen when the nature of the child's disability is such that regular classes with the use of supplementary aids and services cannot provide an appropriate education for the child. A note that LRE also includes access to non-academic settings like the lunchroom, assemblies, field trips, passing time in the hallways, recess, and extracurricular activities. These are all considered to determine LRE for that individual child. So let's go ahead and get started into some specifics related to discipline and requirements under IDEA. This video is focused on school-age students who have IEPs and are entitled to a free, appropriate public education in the least restrictive environment, and students who have a disability but are not yet eligible for special education services, and the school has a basis of knowledge of a disability. There are requirements and procedures that must be followed related to disciplinary removals, protections for students who are not yet eligible for special education services, and appeals if a parent disagrees with a decision that the school made regarding their child. I used the term basis of knowledge in the last slide, so I'm going to break down exactly what that means. This is important to know for students who are not yet identified as a student with a disability under the IDEA. The discipline protections I discussed on the last slide apply to students with individualized education programs, IEPs. Sometimes the same protections also apply to students who don't have IEPs if the school district had a basis of knowledge. This means the school district knows that the student is a student with a disability. There are three circumstances in which the school district would have a basis of knowledge even if the student doesn't have a current IEP. One, the parent requested an evaluation for special education services in writing. While it isn't required that a parent make a request for an evaluation in writing in general, in order for the school district to have a basis of knowledge, the evaluation request from a parent must be in writing. Or two, a parent expressed a need for special education services in writing to a teacher, supervisor, or administrator. This could have been through email, a follow-up letter to the school after a meeting discussing concerns, or any other written documentation expressing concerns and the need for the student to get help, support, or services. Or three, school personnel expressed a specific concern, written or verbal, about a pattern of behavior to a special education director or supervisor. In all of these three situations, the school has a basis of knowledge that the student is a student with a disability. The school is not considered to have a basis of knowledge that a student is a student with a disability if the parent of the child is not allowed the school to do an evaluation for eligibility for special education services. So, for example, a teacher expressed concerns to an administrator and the school requested to evaluate the child for eligibility for special education services, and the parent did not consent to the evaluation. Or the student is eligible for special education and related services under the IDEA, but the parent has refused to allow the school to provide services to the student. Or the student has been evaluated and was determined not eligible for special education related services under the IDEA. It is important to understand this concept of whether the school has a basis of knowledge or did not have a basis of knowledge when we get into the protections and procedures for students who are being disciplined. Keep in mind what I mentioned at the beginning. A student who is eligible for special education services under the IDEA is entitled to a free, appropriate public education in the least restrictive environment. A disciplinary removal means a student is excluded, they're removed from their current educational placement as documented in their individualized education program, the IEP, due to a violation of the school's Code of Student Conduct. While removed, the student is not involved in the general education curriculum, is not receiving instruction and services as documented in the IEP, and is not participating with students without disabilities to the extent that they would have if they were in their current educational placement. So let's go over some examples. These are some examples that are considered disciplinary removals. A pattern of office referrals, extended time away from instruction, or extended restrictions on privileges, requesting a parent pick up a student early from school due to behaviors, repeatedly telling a student to take a day off, repeatedly sending a student out of school with a condition to return. Maybe the school says the student needs a risk assessment or a psychological evaluation and it will take 3 days to get an appointment with the psychologist. Or regularly requiring a student to leave early and miss instructional time. This is called a shortened school day. Another example could be a student in a timeout room with an aide. Disciplinary removals are commonly called suspensions and expulsions, and they can include in-school suspension, out-of-school suspension, expulsion, or a student being removed by school personnel to an interim alternative educational setting. And I'm going to talk about interim alternative educational setting in just a bit. And just a note, even if a student is physically in the school building, if no services are being provided as documented in the student's IEP, if they're not making progress, they are not participating with students without disabilities, and there is no certified teacher providing instruction, an in-school suspension is considered a disciplinary removal. Michigan law defines suspension as removal of less than 60 consecutive school days. It may be a change of placement. This is another concept I'm going to be breaking down in just a few minutes. And that decision to suspend a student is made by a school building administrator. The Michigan Revised School Code defines expulsion as a removal of more than 60 consecutive school days. It's always a change of placement, and the final decision to expel a student must be made by the local school board. Schools have a duty to prevent problems which may lead to suspensions or expulsions of students who receive special education services. When a student with a disability experiences behavioral challenges resulting in suspensions or other disciplinary measures that exclude them from their current educational setting, appropriate behavioral supports may be necessary to ensure the student receives a free, appropriate public education. The IEP team may need to look at current supports and consider if services or supports need to be changed or if additional supports need to be added. Failing to implement procedural requirements or provide needed behavioral supports to a student with a disability may result in the student not receiving a meaningful educational benefit and therefore constitute a denial of a free, appropriate public education and/or a denial of a placement in the least restrictive environment. The school cannot keep suspending a student without addressing the behavior that led to the disciplinary action. Keep in mind that all eligible students are entitled to a free, appropriate public education in the least restrictive environment, and that a student is not removed from the general education environment unless, due to the nature and severity of their disability, they cannot make progress in the general education curriculum, even with the use of supplementary aids and services. This, of course, includes students with behavior challenges. Supports and services to address behavior for these students should be written into the IEP, and a behavior intervention plan, which is a plan that addresses the student's challenging behavior that is affecting their learning or learning of others. School day has the same meaning for all students in school, including students with and without disabilities. Counting partial days of disciplinary removal must be consistent with the district's attendance procedures. For example, when attendance is counted in half days, disciplinary removal should also be counted in half days. Alternatively, when attendance is counted for each class period, disciplinary removal should also be counted for each class period. In general, a school day should not be shorter for a student with a disability than a school day is for students without disabilities. A common example that we hear about at Michigan Alliance for Families is letting a whole class out early to catch the bus before the hallway gets busy. If the IEP team, of which parents are members, determines a student needs a shorter school day due to the nature or severity of that student's disability, there are things that the school team, the IEP team, needs to consider before making the decision about shortening a student's school day. Questions to consider are: what skills is the student lacking to successfully attend the full day of school? How will the removal from school meet the student's educational needs? How will removal from the school help close the skill gap? And how will removal from the school result in educational progress? As well as what services can the team provide to help close the skill gap and educate the student in the least restrictive environment, assist the student to be successful in the school for the entire day, and make progress in the general education curriculum. And what is the plan, including a timeline, to return the student to a full day of school? When a student's IEP team, which can include a medical provider, treatment specialist, and other relevant people, determines a student needs a shorter school day, appropriate modifications based on the unique needs of the student must be incorporated into the IEP to ensure that the student receives that free appropriate public education in the least restrictive environment. A shortened school day should only be in place for a limited amount of time, and there has to be a plan for the student to return to a full day of school. The practice of shortening a student's school day as a disciplinary measure could be considered a denial of that free appropriate public education if the student's IEP team does not consider additional services and supports that could enable the student to remain in school in the least restrictive environment for the full school day before placing the student on a shortened school day. So let's consider some questions. Can a shortened school day be used for a student to manage behavior or as discipline? No. For students with disabilities whose behavior impedes their learning or the learning of others, the IEP team must develop an IEP that addresses the student's behavioral needs through annual goals, related services, and/or supplementary aids and services. The IEP should also include behavioral interventions, supports, and strategies to enable a student to participate for the full school day. Removal from school is not an intervention or support for students with difficult behaviors and is not reasonably calculated to result in educational benefit. The failure of the IEP team to consider and provide needed behavioral supports could also lead to behavior that is inconsistent with the school's code of student conduct. Shortening a student's school day as a disciplinary measure could be considered a denial of a free appropriate public education. Can virtual instruction be used as an alternative to suspension? No, virtual instruction cannot be used as an alternative to suspension for students with disabilities. The school district cannot unilaterally move a student to virtual instruction without implementing the IDEA discipline protections. Any change of placement decision is made by the IEP team and needs to consider whether the student can work on their goals in that setting, whether the setting enables the student to continue receiving educational services and participate in the general education curriculum, whether the setting would be detrimental to the student's progress, and whether the student can benefit from home instruction. The school can't say they won't suspend a student and then the student is put on virtual instruction. This is a change of placement and there are discipline protections and procedures that are required. So now that you have some definitions and an idea of what disciplinary removals look like, let's get into some important information about the length of time of the removals for students who receive special education services. For a student who has an IEP, there is a difference in what happens when a removal is more than 10 school days or less than 10 school days. I'm going to start with removals of less than 10 school days. School personnel may remove a student with a disability who violates a school's code of student conduct from their current educational placement to an appropriate interim alternative educational setting, another setting, or suspension for not more than 10 consecutive school days in the same manner as they do for students without disabilities. And for additional removals of not more than 10 consecutive school days in the same school year for separate incidents, as long as those removals are not a change of placement. So hang in here with me, and I'm getting to change of placement and what that means. The key here is not more than 10 consecutive school days in the same school year, separate incidents, and not a change of placement. Some examples we talked about are when a parent is called to pick up a student due to behavior, or a student is sent to the principal's office, or suspensions of less than 10 school days. A common example I hear is about bus removals. Removal from the bus is considered a disciplinary removal and could be considered a change of placement if specialized transportation is documented in the IEP and part of the student's offer of FAPE, unless the school provides the student transportation in another way. It is not considered a disciplinary removal if it's not part of the offer of FAPE in the IEP under the IDEA. And a reminder that removals are counted by how the district takes attendance. So could be by class period or half a day or AM/PM attendance. Removals of more than 10 consecutive school days are always considered a change of placement. And I'm going to get into this in detail on the next slide. Removals of more than 10 consecutive school days trigger discipline protections for students with an IEP. Remember when I was talking about the obligation of schools to address students' behavior to prevent disciplinary action? This is a protection so schools cannot just keep suspending a student with a disability who is entitled to a free, appropriate public education in the least restrictive environment without addressing the behavior that's leading to the discipline. If there is a change of placement, the district must provide a free, appropriate public education. Services can be in a different setting and different and/or less than what is in the current IEP. The services may be provided in an interim alternative education setting, so this could be at home, in an alternative classroom or alternative school, at the library, or at the board office, just to give some examples. The interim alternative setting is determined by the IEP team, and I'm going to talk more about interim alternative educational setting later on. The school must provide the parent with notice of the change of placement and a copy of the procedural safeguards, and the district must conduct a manifestation determination review and determine if the behavior is a manifestation of the student's disability, that is the behavior related to the student's disability. And this is important because if the behavior was a manifestation of the student's disability, the district must return the student to the prior educational placement. This means the placement the student was in before the removals that led to the change of placement. So I'm going to dig a little bit deeper into the manifestation determination review in just a minute. So when is it a change of placement? I've mentioned change of placement a few times now, so let's dig into what this means. Change of placement occurs if the removal is more than 10 consecutive school days, more than 10 days in a row. Examples are a student is suspended for 12 days for fighting or expelled for 90 days for hitting a teacher. If a school puts conditions on a return to school, for example, they have to have a meeting, or the student has to get an evaluation, or they need to have a risk assessment, each day out is counted as a removal. So if it will take a week for the student to get an appointment for an evaluation or to have a risk assessment done, each one of those days is counted as a removal. So a removal of more than 10 consecutive school days or a series of removals that are a pattern. This is more than 10 accumulative days. So for example, 2 days one time, 5 days another time, 4 days another time, and the behavior is substantially similar to behavior in previous incidents that resulted in the removals. In looking at what is substantially similar behavior, what that means, there are other factors to consider, such as was the behavior similar? So were the removals all for fighting, or some were fighting and some were hitting a teacher? What about the length of the removal and the total time the student's been removed, and how close the removals are to one another? Were there 3 days in October and 4 days in January and 4 days in May? You're looking at how close those removals are to one another. That determination of whether there's a pattern is determined by the district, and it's case by case. Parents can provide information to share their view that the behavior is a pattern, but that final determination is made by the school district. This final determination is subject to review through the expedited due process hearing. I'm going to talk about that in just a bit. In the above circumstances, a manifestation determination review is required for more than 10 accumulative days or a pattern that's determined by the district. Whether or not the district considers the behavior as a pattern or a change of placement, this might be an indication of the need to review or revise the IEP and or consider additional accommodations, services, and or behavioral supports for that student. Parents can request an IEP review meeting to discuss these. So let's break down what the manifestation determination review meeting is about. I've mentioned it a couple times now. That manifestation determination review is an entitlement for students with IEPs, and it's a procedural safeguard. The purpose of the meeting is to answer these two questions. Was the conduct in question caused by or had a direct and substantial relationship to the child's disability? And was the conduct in question a direct result of the school district's failure to implement the IEP? The manifestation determination review meeting must be held within 10 school days of determining the change of placement, and parents must be notified of the meeting in a reasonable time and provided an opportunity to attend. There is no definition of reasonable time, and the notification doesn't have to be in writing. If a parent doesn't attend the meeting, the school can hold the meeting without the parent. So it's very important for parents to attend this meeting and provide their input. The meeting is made up of IEP team members. The school district and parents each invite who they feel has knowledge and special expertise regarding the student and the situation to share relevant information and to participate in the manifestation determination review process. And this can include attorneys, private and school therapists, counselors, teachers, advocates. A manifestation determination review can be conducted for a student who is not yet eligible for special education services if the school has a basis of knowledge that the student is a student with a disability. So if a student who is not yet eligible for special education services keeps getting suspended, they have an entitlement of an MDR as well. So let's talk more about the manifestation determination review discussion. What does the disability look like for this specific student related to the specific behavior leading to the change of placement? Not what it looks like in general, but for this specific student. And let's remember the purpose of the meeting and the two questions being answered. Question 1, participants must look at all information in the student's file, as well as information provided by the parent and from private therapists, medical professionals, etc. All information about the conduct that led to the change of placement, as well as information about the student's disability, should be reviewed and discussed. It's not just about the latest discipline report. Maybe there's a new diagnosis that was shared with the school, or maybe the parent has been noticing some new behaviors, or there's a family event that's impacting the student's behavior. Maybe the family just moved, or there's a divorce or a death in the family. The behavior leading to the disciplinary action must be directly and substantially related to the child's disability, and all information should be reviewed thoroughly, not just information related to the student's category of eligibility for special education services. The information should present a whole picture of the student, not just a focus on the specific eligibility category. Whether the behavior is found to be a manifestation of the child's disability is determined on a case-by-case basis. The behavior for one child might have a direct and substantial relationship to the disability, but maybe not for another child. Look at all the information. It's critical for parents to be able to explain how their child's disability impacts them in school and show the connection between their disability and the behavior leading to that discipline. And then question 2, was the conduct a direct result of the school district not implementing the student's IEP? It's not about whether the IEP is appropriate or not appropriate, or if there's information missing, or if a parent doesn't agree with the way something is written. It's about whether the school implemented the IEP as written. In order for a team to avoid predetermining what they think the answers to the questions are, a thorough review of information is required. So the team is going to be reviewing the IEP, observations and information of those working with the student, privately and in school. Information provided by the parent, like I said, maybe it's a new medical diagnosis or they're seeing some new behaviors. This information should be shared with the school. School and private evaluations that were done, therapy and behavioral reports, again from school and private therapists, grades and progress notes, discipline reports, not only just the most recent, but the student's discipline history, and then information about the current misconduct. A reminder that the information shared is intended to present a picture of the whole child, not just a specific focus on the eligibility category for which the student receives special education services. As an example, if a student is eligible for special education services under autism spectrum disorder, this is the eligibility category marked on the IEP, but they also have a medical diagnosis of attention deficit disorder. This information must be documented in the IEP and discussed as well. Decisions are reached by consensus and not a vote. Documentation is made of all information discussed, and this includes information shared by the school and parents. If the parent, the school district, and relevant members of the IEP team cannot reach agreement on whether the student's behavior was or was not a manifestation of the student's disability, the school district makes that determination and provides the parent prior written notice. Parents have dispute resolution options available to disagree with the decision, and we're going to discuss those in just a bit. Student discipline law changes went into effect with the 2017-2018 school year. Michigan law requires that 7 factors be considered before suspending or expelling a student for certain offenses or violations of the school's code of student conduct. The revised school code provides each school district with the authority to establish local discipline policy and to suspend or expel students after considering the 7 factors, which include consideration of lesser interventions. I'm talking about the 7 factors in the context of that manifestation determination review for students with disabilities. However, this law applies to all students. It's not just for students with disabilities. The 7 factors for consideration are the student's age, the student's disciplinary history, whether the student is a student with a disability, again, as being discussed at the manifestation determination review, the seriousness of the offense or behavior, whether the offense or behavior committed threatened the safety of any student or staff member, whether restorative practices will be used to address the offense or behavior. Restorative practices take an approach that involves all of the affected parties in working together to resolve the conflict and addresses the harm that was caused by the conduct. And then whether a lesser intervention would properly address the offense or behavior. This consideration of the 7 factors before suspending or expelling a student includes offenses such as physical assault against a student, criminal sexual conduct, gross misdemeanor, or persistent disobedience. And persistent disobedience isn't defined, so it really could apply to almost any situation. So certainly the 7 factors should be considered for all suspensions and expulsions, if only for inclusion of all relevant information. And the IDEA says all relevant information should be considered. Consideration of the 7 factors also includes offenses involving a weapon, arson, and assault against staff. Definitions are described in the law that is on the slide at the beginning of the presentation with the rules, regulations, and guidance. There is no discretion about whether the consideration has to be done, only how it's to be done. The 7 factors takes into account whether the student is a student with a disability or whether the school had a basis of knowledge that the student is a student with a disability. And this is why it's important to look at all the information in the student's records. Was an evaluation requested? Were concerns documented in writing and submitted to school professionals? Is there a pattern of behavior that the school has seen that's not being addressed? So let's look at the possible outcomes of that manifestation determination review decision. The first column down is question 1. The second column down is question 2. The first 3 responses all have an answer of yes for both questions, or at least one of the questions. For all 3 of these outcomes, the behavior is related to the student's disability. At least one of the questions has to have an answer of yes for the behavior to be related to the student's disability. For the last row, the answer was no to both questions. This is the only outcome in which the behavior is not related to the student's disability. If the behavior is not related to the student's disability, the student can be removed according to the district's Code of Student Conduct in the same manner and for the same duration as a student without a disability. However, the student must be provided service that will allow them to continue to participate in the general education curriculum and allow an opportunity to progress toward their IEP goals, though this could be in a different setting. And there is no requirement or expectation that the student services be duplicated in that alternative setting. The IEP team must convene to determine what services will be provided and in what setting. The school must consider conducting a functional behavioral assessment and implementing a behavior intervention plan anytime a child is removed for more than 10 days if considered appropriate. The functional behavioral assessment will help figure out the function of the behavior. The student is still entitled to a free appropriate public education, but it could be less services than in the current IEP, and the services may be different. There may also be a different educational setting. These could be homebound services, or services may be provided in the board office, just to give some examples. The IEP will be reviewed and revised periodically and at least annually, or if there is new information. The IDEA requires that the IEP revision occur when a placement change occurs. The key points here are that the student can be moved to another educational setting that's determined by the IEP team, and parents are part of the IEP team and are involved in this decision. The student still is entitled to a free appropriate public education, though it may look different. It might be in a different setting, and there might be a different type and amount of services, and the behavior must be addressed. Parents must be given information about what they can do if they disagree with that manifestation determination review decision. If the behavior is found to be related, the student must be returned to the placement from which they were removed. However, the parent and the school district can agree to a change in placement as part of the IEP process, or an administrative law judge can order a change in placement, and we're going to talk about this in just a bit. A functional behavioral assessment and behavior intervention plan are required if the outcome of that manifestation determination review is related. When the behavior is related to the child's disability, sometimes behavior intervention planning may take place immediately following that manifestation determination review meeting. If the behavior has not been addressed in the IEP already, the IEP should be revised to include strategies, including positive behavioral interventions, supports, and services to address the behavior and ensure that the student receives services appropriate to their needs. A change in placement that is appropriate and consistent with the student's needs may be implemented. School must provide notice and procedural safeguards to the parent. And then finally, if the IEP is not being implemented, the school must take immediate steps to remedy the failure. During the manifestation determination review, a student may be placed in an interim alternative educational settings in any one of the following situations. The school and parents may agree on an alternative placement through the IEP process, or school officials may move a student to an appropriate alternative educational setting for up to 45 school days if the student brings a weapon to school, uses, sells, or possesses illegal drugs at school, or inflicts serious bodily injury upon another person at school. So this doesn't include things like phones, rulers, books, or other items that don't meet the definition in the law of weapon. So the student may have violated the school's code of student conduct because they used an object to hurt someone, but this does not make the object a weapon for the purpose of moving a student to an interim alternative educational setting. And you can refer back to the Michigan Revised School Code information on slide 3 to understand and learn more about the definitions of weapons, drugs, and serious bodily injury. A parent can appeal this placement, and we're going to talk about appealing that manifestation determination review decision in a few minutes. And during an appeal of a finding that a student's behavior is not a manifestation of his or her disability, the student may be moved to an interim alternative educational setting. A hearing officer may order that a student be moved to an alternative educational setting for up to 45 school days if the hearing officer finds that keeping the student in the present placement is substantially likely to result in injury to the child or others. And there also could be a court order for the student to be placed in an interim alternative educational setting. The school district must continue to provide educational services to the student and address the student's behavioral needs, but that free appropriate public education that we've talked about a few times, it can look different. And just to note that if transportation is in the student's IEP, the school district must provide transportation as that part of the offer of a free appropriate public education. Parents can appeal the interim alternative educational placement to keep the child in the current placement. This is called stay put. And the interim alternative educational setting is an IEP team decision. And the school district must give parents prior written notice and a copy of the procedural safeguards. Parents and the school may disagree about the outcome of the manifestation determination review meeting, and there are procedural safeguards available under the IDEA. The parent or any IEP team member can write a dissenting report, and this is a report in disagreement with the manifestation determination review decision. The parent and the school can agree to mediation through special education mediation services. If the parent and school agree on how to resolve the issue, then a legally enforceable agreement is developed. Another way to challenge the manifestation determination review finding indirectly is to request an independent educational evaluation. An IEE is like getting a second opinion. It's a request for an evaluation to be completed by a professional that does not work for the school district after the school has conducted their own evaluation of the child. And you can ask for an IEE if you do not agree with the functional behavioral assessment or if you requested updated evaluations and don't agree with them. A parent may disagree with any finding made by the school or the IEP team during the manifestation determination review process by signing the MDR in disagreement and filing a due process complaint and requesting a due process hearing. And a parent or anyone can also file a state complaint alleging that the school district violated or failed to implement legal federal laws and state rules related to special education or the student's IEP. A due process complaint alleges violations on matters under Michigan Administrative Rules for Special Education or the Individuals with Disabilities Education Act. A due process complaint can only be initiated by a parent or by the school district, and an expedited due process complaint and hearing is only used to appeal a district's manifestation determination review decision. A parent can file an expedited due process complaint requesting an expedited due process hearing to appeal the school district's manifestation determination review decision. In a situation where the child is returned to a placement before disciplinary action occurred, the school district can request an expedited hearing if they believe that maintaining that current placement of the child is substantially likely to result in injury to the child or others. But ultimately, the administrative law judge will decide if the due process hearing will be expedited or not. In an expedited due process hearing, the process is the same, but the timelines are shorter than for a standard due process complaint and hearing. The required resolution session must start within 7 calendar days of the expedited complaint being received, and the resolution session is a meeting used as a last resort to resolve the issues without going to hearing. The resolution session can be waived if the parent and school agree to, or the parent and the school agree to go to mediation. The hearing must be held within 20 school days, and the decision and order must be mailed within 10 school days after the hearing ends. The school can move your child for up to 45 school days, even if you disagree with that move, to an interim alternative educational setting if the current placement is likely to result in injury to your child or others. And the decision must follow certain procedures, and the assigned interim alternative educational setting is an IEP team decision. During those 45 school days, the school is required to provide services to address the child's behavioral needs. When a parent or the school has filed a due process complaint related to disciplinary matters, the child must remain in the interim alternative educational setting unless the parent and school district agree otherwise, pending the due process hearing decision. Before the change occurs, as written in the prior written notice, you must act to show you are disputing the change by filing a due process complaint, requesting hearing, or requesting mediation. If a student with an IEP is expelled, the student is still entitled to a free appropriate public education. As I've mentioned a few times, that free appropriate public education may look different. It might be less services, and it might be a different educational environment. It's the responsibility of the parent to locate a suitable alternative education program and to enroll their child in a program during the expulsion. A student who's been suspended or expelled from his or her resident district for any reason may attend a non-resident alternative education program without the resident district's approval. The school district is not required to provide the same special education services or settings as documented in the IEP, but must enable the student to continue to participate in the general education curriculum and make progress towards meeting their IEP goals. Home-based instruction is only used as the result of disciplinary action, and this is not to be confused with homebound services. It must address the student's IEP goals and consideration of the potential harm to the student and the quality of services. It must offer an educational benefit and access to non-academic and extracurricular activities. At Michigan Alliance for Families, we help parents to be as prepared as they can for issues that might arise with their students. It's about being proactive and ensuring your student has the supports and services they need in place at school. Be familiar with the federal laws, state rules, and Michigan Department of Education Office of Special Education guidance regarding discipline protections for your student. Know your school's Code of Student Conduct and the school board policies. The school's Code of Student Conduct policy should be consistent with the school board policies and align with the law. Keep open communication with the IEP team and address concerns about your student's behavior quickly and prevent challenging behaviors before they occur by ensuring appropriate behavioral support services are in place. Keep your own documentation and data about disciplinary removals and behavior incidents, and review and revise your child's IEP as needed to ensure all needs are addressed in the IEP, including behavioral needs. Ask lots of questions and know your options if you disagree with a decision that is made regarding your child's education. If you have concerns about your child's education, reach out to your regional parent mentor at Michigan Alliance for Families. We are here to support you. Thanks for tuning in.